Welcome back to The Explainer. Today, we're unpacking a really fascinating one. We're looking at the landmark 1989 Indian Supreme Court case, V.K. Rama Rao v. Nabard. Why? Because to truly understand the legal roots of modern salary disputes, you've got to look back. If you've ever wondered how the law balances plain old math with actual workplace fairness, you're in the right place. Let's get right into it.
Okay, let's dive into this. Think about your own company, or maybe a massive corporation you know that's going through a merger right now. Why do pay disputes actually happen today? Usually, it boils down to the friction that sparks when legacy employees and brand new hires suddenly collide and are forced onto the exact same new payroll system. The math gets incredibly messy, and man, the feelings of unfairness can be intense. So here's our roadmap for today. First, we'll look at the modern pay dispute. Second, the specific Nabard grievance. Third, we'll break down the actual mechanics of fitment. Fourth, the legal battle lines. And finally, the Supreme Court verdict. We're going to use this specific historical grievance to really master a very modern, highly relatable workplace equity issue. All right, Section 1, the modern pay dispute, legacy versus new hires. Look, anytime you try to cram two totally different generations of employees onto one unified payroll, you're absolutely going to get a mathematical headache. It creates an instant clash of perspectives. On one side, you've got your legacy employees. When a new pay system rolls out, especially if it's applied retrospectively, they often get hit with what we call a transition anomaly. Basically, their old pay doesn't map perfectly onto the new scale. Then on the flip side, you have the new hires. They walk through the door, enter the new system seamlessly, and look at any special adjustments being handed to the older staff, and they demand identical administrative treatment. Honestly, from a completely impartial standpoint, both sides feel entirely justified in their stance.
Section 2. The Nabard grievance, a constitutional clash. This image right here brilliantly illustrates the core conflict we're dealing with. Back on February 24, 1986, the National Bank for Agriculture and Rural Development, or Nabard, revised the pay scales for all its officers. But they applied it retrospectively, backdating the whole thing to February 1, 1984. Now, to transition the existing employees without accidentally dropping their pay, the bank granted what are known as fitment increments. But here's the catch. 6 petitioners who joined or were promoted after that 1984 anchor date didn't get those specific increments. So they filed a constitutional grievance. Their argument? They occupied the exact same roles as the older employees, so skipping those increments violated their right to equal pay for equal work under Articles 14 and 16 of the Constitution.
To really ground ourselves in this, let's walk through the timeline. February 1, 1984 was that absolutely crucial anchor date. That was the effective retrospective date for pay revisions across the entire banking industry. By November 1984, the Nabard Officers Association was demanding a pay revision to mirror the Reserve Bank of India, the RBI. Then, in October 1985, the RBI officially revised its scales, again, backdated to that February 1984 anchor. Finally, in February 1986, Nabard took action. They revised their own scales to achieve parity with the RBI, and they used a refixation chart to actually make the math work for their existing staff. You can see how that 1984 anchor date rippled all the way into the 1986 administrative action. Now, what's really interesting about this slide is the fundamentally different entry dynamics of these two cohorts based on that retrospective date. Legacy employees were already in service prior to the anchor date. That meant their existing real-world pay had to be mathematically mapped onto a newly created scale. They literally needed fitment adjustments to prevent their paychecks from shrinking. Now, look at the newer petitioners. They entered the system after the retrospective date. They didn't have a transition problem because, legally speaking, they entered when the new scales were theoretically already active. So they were just automatically placed on the new scales from day one, no fitment adjustments needed. Moving right along to Section 3, the mechanics of fitment, visualizing the math. Okay, so what exactly is this dense legal jargon, a fitment increment? Simply put, it is not a permanent promotion. It's not a superior pay scale. It's just a temporary, corrective, administrative device. Its literal only purpose is to bump an employee to the nearest higher stage in a new pay scale just to prevent a drop in their take-home pay during a transition. That's the whole shebang. I want to guide you step by step through this crucial visual here, this staircase, because it makes the math perfectly clear. On the left, in gray, you have the old pay scale. On the right, in blue, is the new pay scale, which has different, wider steps. If you take a legacy employee and try a strict stage-to-stage transfer directly across, you hit a snag. See that red dotted line? That's a sudden drop in pay. And obviously, no way can you reduce an employee's actual salary during a so-called pay upgrade.
So the bank uses that gold arrow you see there, the fitment increment. It bridges the financial gap, bumping the employee up to the nearest logical step on the new blue staircase. It acts as temporary personal pay until it merges with their normal future increments.
Section 4. The legal battle lines, precedents, and proportions.
So, how did the actual arguments play out? Well, the petitioners tried to rely on some older Supreme Court precedents to prove discrimination. They cited cases like DS Nakara, which struck down dividing identical pensioners based on an arbitrary retirement date. They also brought up Pisa Vita, a case that struck down artificially splitting draftsmen into senior and junior just to give them different pay scales. But these arguments failed. Why? Impartially speaking, it's because Nabard's anchor date wasn't just pulled out of thin air. It was strictly tied to an industry-wide revision. More importantly, Nabard didn't create arbitrary separate pay scales. Both the old and new employees received the exact same revised pay scale. It was only the adjustment method to get them onto that scale that was different.
And then there is the sheer scale of the dispute. It was 2,284 against 6. The refixation chart that utilized all these fitments was entirely approved by the Nabard Officers Association, representing 2,284 fully satisfied union members. Sitting on the other side were just 6 complaining petitioners claiming a grievance. It's really a fascinating subversion of your typical David versus Goliath story. To address this kind of massive imbalance, courts often rely on the philosophy of the needs of the many. Let me read you this quote from a related case, RBI versus Saharamnan. In service jurisprudence, there cannot be any service rule which would satisfy each and every employee, and its constitutionality has to be judged by considering whether it is fair, reasonable, and does justice to the majority. Fortunes of some individuals is not the touchstone. Essentially, isolated grievances from a tiny fraction of people don't easily invalidate an industry-wide uniform settlement that is clearly working for thousands of others.
And that brings us to Section 5, the Supreme Court verdict, equity over identity.
Let's move to and see how this all builds into the final synthesis. The Supreme Court ultimately concluded that fitment increments are absolutely not discriminatory. In fact, they're eminently just because they achieve a dual-purpose framework. Pillar 1 is mathematical necessity. You literally have to adjust salaries without causing financial harm to the current staff. And Pillar 2 is equitable reward. It's a way of acknowledging and rewarding the past service of the existing employees who actually built the institution prior to the revision. The court actually made an incredibly powerful observation here regarding the ultimate fallacy of treating unequals equally. They stated, to deny them such adjustment is to treat them unequally by ignoring their past service and placing them on par with the new entrants. It is therefore an absence of fitments and adjustments and not their application which results in discrimination. Think about that. Blindly treating everyone identically on paper, completely regardless of their actual tenure or context, is exactly what causes unfairness.
So, the crucial point is this. The petition was ultimately dismissed based on 3 main pillars in the final judgment. Step 1. Retrospectivity requires classification. If you backdate a pay scale, you inevitably have to classify employees into pre-revision and post-revision cohorts. Step 2. Fitment is inevitable. To actually give your older employees the benefit of the new scale without shrinking their pay, transition adjustments are mandatory, not discriminatory. And Step 3. Equity is greater than identicality. True constitutional equality involves equitable adjustment based on context, not just demanding identical administrative treatment across the board.
Which leaves us with a pretty provocative question for you to ponder about your own modern workplace. Does true equity in today's workforce require looking at context, rather than just demanding identical paychecks on paper? VK Rama Rao v. Nabard showed us way back in 1989 that fair isn't always identical, and sometimes math needs a bridge to cross over into actual equity. It's the exact same fundamental friction driving why pay disputes happen today. Thank you so much for joining me on this explainer. Keep asking right questions, and I'll see you next time.